Thank you for joining us today, and welcome to Smith, Gambrell, and Russell's live webinar on the topic, GDPR is here and what to expect now. Today's webinar will be approximately 1 hour. CLE credit has been applied for, and we will update you all once we receive the approved course number. Presenting today's webinar will be SGR's Brett Lockwood and Emily McConnell. Brett is a partner in the corporate practice and the chair of the firm's technology law practice in the Atlanta office of Smith, Gambrell, and Russell. Emily McConnell is an associate in the firm's corporate practice. Brett's practice areas include mergers and acquisitions, cybersecurity, and data privacy, as well as technology transactions and licensing. Emily represents domestic and international clients in a variety of corporate and transactional matters, including mergers and acquisitions, commercial transactions, and cybersecurity issues. As you have questions, please place them in the chat and we will address them at the end. Now I'd like to turn it over to Brett Lockwood to begin the presentation.
Hi, good afternoon. Thank you so much for joining us today. This is Brett Lockwood, and I'm here with my colleague Emily McConnell, and we're going to try today to demystify some of the confusion around the GDPR, Europe's General Data Protection Regulation. And there has been a lot of confusion since the GDPR has come into effect about 2 months ago. And so we've got an agenda where we hope to both explain some things and connect some dots for you. So our agenda today, we're going to go over the principal obligations under the GDPR, and then we'll move to some related developments since the effectiveness of it and some things that are going on here in the US that we think attendees should take account of, and companies as they're dealing with the GDPR. And then a high-level comparison of the US and the EU regulatory approaches. And then we'll talk about compliance and best practices. And as Jaleesa just mentioned, we do encourage you to ask questions along the way. Take advantage of the Q&A feature on the webinar, and toward the end of the program, we'll come and address as many questions and any comments as time will allow. So with that, we'll go ahead and jump right into the GDPR itself and give you an overview of that and talk about some of the key requirements. So as I mentioned, the GDPR was effective approximately 2 months ago. It came into effect May 25th. And it, notwithstanding the fact that companies had a fairly long window of opportunity to prepare for it, there really was a lot of scrambling leading up to that, particularly in the months and weeks just before it. And there continues to be a lot of scrambling for some good reason that we'll talk about. And if there's one takeaway that we would have you take note of, is that it's not too late. And if you're still getting up to speed with GDPR, there's still a lot of time and you're in good company to do that. So the GDPR replaced an earlier privacy directive that had been around for a few decades, the 1995 EU Privacy Directive. And one of the principal reasons that the Privacy Directive was replaced with the GDPR is that the Privacy Directive, by the nature of it being a directive rather than a EU-wide regulation, allowed each individual European Union member country to enact different national laws to carry into effect the goals of the Privacy Directive. And there was a lot of inconsistency in the implementation of a European-wide approach. And so the GDPR is intended to bring a lot of uniformity and in some extent, to some extent for business organizations dealing with personal data and compliance issues, that's a good thing. You don't have the patchwork across Europe of many different national laws to comply with. So that's probably a benefit of the GDPR. But the benefits might immediately stop there on the company side, and then you've got a lot of compliance obligations, which are much more rigorous than what the Privacy Directive allowed. And we'll dig into some of those specific rights, but certainly there are a lot of enhanced personal rights, a lot of notice obligations, affirmative consent requirements, and the like. So the GDPR is very broad in scope, and it's very process-oriented. And to some extent, and you'll hear some echoes of this throughout the presentation in both my and Emily's comments, the documentation piece is a significant piece of getting compliant with GDPR, but it's probably the easier piece. The much tougher piece is making sure that as an organization, you've got processes in place to respond to the requirements and the other obligations and requests that you might get under a GDPR, the GDPR approach. And finally, just by way of summary, the thing that has probably gotten the most attention for the GDPR is the sizable penalties that are proposed for violations. And it's the greater of 20 million euros or up to 4% of worldwide revenue. So 20 million euros by itself is fairly significant as a penalty in the data privacy cybersecurity realm. But 4% of worldwide revenue for some companies, and really pretty much any company of any size, is a material number and could be quite sizable. So that's really eye-popping, and it's gotten a lot of attention. So when we talk about the GDPR, there are a number of terms that most of which have been borrowed from the 1995 Privacy Directive, but just to touch upon them briefly, because we'll be using them throughout this presentation, is the concept of a data subject. That's pretty much any identified or identifiable natural person, and you'll notice that it's not necessarily limited to individuals in Europe, which we'll talk about along the way. Personal data, so that's pretty much any information relating to a data subject and from which a live natural person can be identified. So it's a fairly broad concept of personal data. Processing is this idea of pretty much any operation that can be performed on personal data. So that includes things as mundane as handling of personal data, processing it within computing and IT systems, transmitting it, anything along the way where data is essentially touched in some manner by an organization or its IT systems. A controller is another key concept, and that's really the entity, such as an employer organization, that determines the purposes for which the data is actually processed or handled. And then there are processors, and processors are, I guess, best thought of as third parties, contractors to controllers, people who, or companies that help controller organizations actually do all of the things that need to be done with data. So for instance, a cloud services company, software company that is hosting employment data or is hosting a CRM database, that would be a processor company. So those are some of the key definitions that you'll hear, and terms that you'll hear repeatedly. In terms of the scope of the GDPR, it's a very broad scope, and there are some other scope aspects of it, but I think the most important scope aspects are what's reflected on this slide here. And so the GDPR applies to the processing of personal data, either in the context of activities of an establishment that's a controller or processor. So just think of an organization that's handling data some way that's in the European Union, regardless of where the processing occurs. So for instance, let's say you've got a French product company of some sort that's processing data of its worldwide employees. It has employees all over the world, but the company itself is located in the European Union in France. And let's say it outsources that processing activity to a cloud services, HR cloud services company, fairly common model. There are a lot of companies out there that are in that niche, and that cloud services provider is in the US. So even though the data is in the US, and it might actually involve data of individuals who are outside Europe as well as inside Europe, and because the French company is actually in Europe and would be considered to be a data controller, the GDPR applies to that in that situation. So that's one broad category of where the GDPR applies. The next is potentially a slightly broader category because it picks up entities that are not even EU entities and may not even be in the European Union. And so that is where in bullet 2 there that you see, data subjects who are in the processing of personal data of data subjects who happen to be in the European Union, but by a controller who is not itself in the EU, and where the processing is related to the offering of goods or services to individuals in the European Union or the tracking of their behavior. So for instance, let's say you're a US hotel company and you have hotels all across the US and you want to run a promotion targeting, let's say, consumers in Germany. So you do an online promotion, you send an email blast offering them some sort of discount for a stay at a hotel in New York or Atlanta. Well, if you've got consumers who respond to that promotion and sign up for a hotel stay, book a hotel stay through that promotion, you've captured data of EU persons through the targeting of a service, a hotel stay at those individuals, and therefore under the rules of the GDPR, you have compliance obligations. So those are the two big categories, which are fairly comprehensive. So essentially it boils down to if you're processing personal data of a person in the EU as part of targeting goods and services, or if you're a controller or a processor in the European Union, then GDPR applies. And so it's a fairly broad scope of application. So what are some of the requirements of the GDPR? So we're going to walk you through some of the basic ideas that are running through the GDPR. So first of all, some governing principles. And these principles, and I'm not going to go through them all, but these are essentially touchstones, and that to the extent that if an organization is dealing with whether GDPR applies and what they ought to do, these principles are the guiding ideas that one should test your data handling and data processing obligations against. So, and these are consistent with this idea that is sometimes heard called privacy by design. And so privacy by design is one of these ideas that underlies the GDPR. It underlies things such as the US Privacy Shield, which is related to processing data out of Europe. The one thing that I'd highlight in particular is this first bullet point, that processing must be lawful, fair, and transparent. And that comprehends a lot of different things, but it in particular comprehends this idea of informed consent, full disclosure, so that's transparency, lawful, so you actually have to have a legitimate purpose or a basis for processing the data. So let's dig down a little bit deeper into some of the requirements. So affirmative consent from data subjects is required, or there has to be some other lawful basis to process data, to handle data. And so if you haven't actually got affirmative consent, then you need to find some other legitimate basis. And for the most part, the bases for processing data, if you haven't got affirmative consent, follows some common sense ideas, but legitimate interest is a fairly broad one that many business situations and organizational situations fit into. So for instance, the interest that a business has in doing direct marketing activity is something that's considered to be a legitimate interest. Processing data by employers of their employees is a legitimate interest. Another big category or justification for processing that doesn't require consent is fulfillment of a contract. So if you're a company that or organization that's a contract that requires you to process data for an entity that presumably might be a controller or maybe a processor entity for which you might be a subcontractor, if you're fulfilling a contract that deals with data, that's another legitimate basis to be processing data. So, but if you don't have one of those bases, then you do need to go out and get affirmative consent from the data subject. And it needs to be informed consent. You must provide notice to data subjects about your data practices, and the GDPR sets forth a whole slew of specific requirements that have to be in the notice and what you need to say, such as holding periods, retention periods for data. You have to give data subjects notice of different rights that they have. And among the rights that they have is the right to access data, correct incorrect data that they become aware of, request erasure in certain cases of data. That's sort of the right to be forgotten notion, which is sometimes spoken about with respect to European data privacy matters. Have portability of data for certain kinds of data that's processed, and restrict processing, and if consent is the basis for processing, to withdraw that consent. And those are all elements that need to be in your notice of your data practices to data subjects. So it's a fairly extensive roster of things that need to be dealt with and that data subjects have rights around. And then a further requirement intended to essentially protect the data and protect data subjects is that you have to, as an organization subject to GDPR, implement and document appropriate organizational safeguards to protect data. And the documentation requirement is an important one. Of course, if you're going to go through all this trouble, presumably you would document it. But if you're a smaller organization, specifically one less than 250 employees, you're exempt from the documentation requirement, but you still need to implement the appropriate safeguards. Contracting practices are also addressed in the GDPR. Contractors handling data have to adhere to certain written contractual requirements that the GDPR specifies. And if your organization may have gone through the activity of sending out notices, consent notices, or requests for consent and requests to process data to individuals who might be in your database, and you probably have also either received or been asking for data protection addendums or data protection agreements to supplement existing contracts. And most of that activity has been driven by this second bullet on this slide in an effort to conform to the contractual requirements that processors and controllers have. And finally, you have to maintain a record of your processing activities. Seems pretty straightforward, but if there are issues later, you need to be able to have those records available. Next, coming into data breach notice. So here in the U.S., we pretty much think of data privacy and cybersecurity beginning and ending at data breach notice requirements, but in Europe, it's just one small piece. But if you do have a data breach situation, you only have 3 days or 72 hours to report the breach to the supervisory authorities in the appropriate state. And that's very quick. Compare it to here in the U.S., probably the quickest notice requirement is in Vermont, which is a 14-day requirement. But that's to the regulatory authorities in Vermont. And the idea here is with this notice requirement, even though it's short, it's to give an early heads up to regulatory authorities, and then you've got additional time to report it to individuals. If data is highly sensitive, and sensitive data is considered to be health data, political information, philosophical or religious information, you have to perform what's called the DPIA, a data protection impact assessment, and essentially assessing risk to individuals. And in appropriate situations, you might actually have to go out and consult with the regulatory authority. And finally, just note, if you're engaged in large-scale processing, and large-scale is not clearly defined, so you've got the extremes. Let's say if you're a very large software organization such as Google or Facebook, you're processing hundreds of millions of individual data subject files, then that's clearly large-scale processing. But what about a much smaller organization, even one with smaller than 250 employees? Is that large-scale? But in any event, if you fit into this category of large-scale processing or monitoring, you have to appoint a data protection officer. And a data protection officer, or DPO, has certain specific obligations that they have to adhere to and certain reporting requirements. And on the other hand, if you're whether you're large or small, but if you're processing personal data of a data subject that's subject to the GDPR, but you're not in the EU, you do have to appoint something called a personal representative. And it appears that this idea of the personal representative is akin to a registered agent. But a registered agent in the U.S. context is pretty much an entity or a person that receives service or process and doesn't really do much more beyond that. But in the GDPR context, in a peculiar way, this personal representative, the person who has the privilege of serving that position, has joint and several liability for any problems associated with the entity's data processing practices. So it's a pretty big role to undertake, and it's probably one of the roles that a lot of U.S. companies that find themselves subject to GDPR and don't have to appoint a DPO, a data protection officer, are probably holding back on until the obligations of a personal representative and the liability is a little more fleshed out by some regulations. And finally, just note by way of major requirements for under the GDPR, to the extent you're transferring data outside the EU, which is a very common situation these days, data seems to know no borders, and companies and organizations all across the world send data all around the world. If you're sending data outside the EU, it can only be sent to a place where there's an adequate level of protection. And in the U.S., the U.S. is actually not a jurisdiction where an adequate level of protection is considered to be assured because the U.S., I guess, relative to Europe, is almost like the Wild West in terms of our data and cybersecurity practices. So we do have this thing called the U.S.-EU Privacy Shield, and about 3,000 companies have opted into this Privacy Shield, and it's a sort of safe harbor that companies can opt into if they're outside Europe. And if you're part of the EU-US Privacy Shield, you're considered to be providing an adequate level of protection. But the Privacy Shield has been a subject of a lot of controversy, and it's actually subject to current review. And as of September 1, we'll have to see if it remains in effect, because there's some issue with the European Parliament not being satisfied with it. So September 1 is a key date. Hopefully the Privacy Shield continues. But if you don't have the Privacy Shield to take advantage of, there are these model clauses that were in effect under the 1995 Privacy Directive, which are very cumbersome and don't always map to common sense, but they're out there, and you sometimes see them as addendum to contracts simply to comply with the GDPR. So at this point, I'm going to turn it over to my colleague, Emily McConnell, to take you through some post-May 25th developments and some other US-related things that might be of interest.
Yes. Thanks, Brett. So today marks exactly 2 months since the GDPR came into effect, so it's a good time to take a step back and assess what we're seeing in terms of enforcement. So far, we've seen some action at the individual or consumer level. On the day that the GDPR came into effect, the privacy lobby group called None of Your Business, or NOYB, which is led by Austrian privacy activist and attorney Max Schrems, filed complaints against Google, Facebook, Instagram, and WhatsApp. The essence of these complaints is that these companies are relying on process personal data in violation of the GDPR. In other words, that requiring users to click that they accept these companies' data collection policies in order to be able to use the services or platforms offered by these companies doesn't amount to freely given consent, which the GDPR requires if you are using consent as your legal basis to process personal data. There are currently about 20 other complaints that the European Data Protection Board is starting to investigate that have been brought by individuals or by groups on behalf of individuals. By contrast, it's been quiet from the supervisory authorities so far, indicating that the EU intends to take a measured approach with respect to enforcement and that it may take a few more months before authorities start to impose penalties for violations. And this measured approach regarding enforcement is consistent with the EU's intent that companies view the implementation of the GDPR as only the beginning and consider compliance as an ongoing practice that is taken very seriously. So for now, the effort by entities should be on demonstrating that they don't take privacy matters lightly and avoiding egregious violations. That being said, compliance isn't necessarily cut and dry because there's certainly some aspects of the GDPR in need of clarification. And one gray area is who is actually considered a data subject under the GDPR. As Brett noted in the key definition slide earlier, data subject is very broadly defined as an identified or identifiable natural person. The definition itself doesn't distinguish between EU residents or citizens on the one hand and US or non-EU individuals on the other hand. Presumably then anyone anywhere in the world can be a data subject. Of course, the territorial scope provisions of the regulation serve to limit the GDPR's applicability somewhat, but these provisions present other issues that need to be fleshed out as well. We know that the GDPR applies to the processing activities of companies based in the EU, even if the processing takes place outside the EU, and that the GDPR applies to the processing activities of companies that are not based in the EU if their processing relates to offering of goods or services to data subjects in the EU or monitoring the behavior of data subjects in the EU. However, there are a number of scenarios that don't fit neatly into these categories, such as US companies processing the personal data of EU residents or citizens while they are studying, working, or traveling in the US. Or consider a US citizen who is studying in Europe via an exchange program based in the US. In these situations, it's unclear whether the GDPR would apply. Let's assume, however, that the GDPR does apply to an entirely US company or a US subsidiary of an EU company. Another issue is how the EU can establish jurisdiction over such a company and impose fines for non-compliance if the company has no physical presence in the EU. One way that the GDPR attempts to deal with this issue is the personal representative requirement, which Brett mentioned earlier. And this is a requirement that a non-EU controller or processor that processes the personal data of data subjects in the EU designate a representative located in the EU to act on the non-EU controller or processor's behalf with respect to its obligations under the GDPR. There are some exceptions where representative isn't required, such as when the processing is occasional, it doesn't involve large-scale processing of special categories of personal data, or the controller at issue is a public authority or body. However, if a representative is required, the GDPR provides that such representative will be held jointly and severally liable with the controller or processor at issue for the controller or processor's noncompliance, which is pretty significant and raises the question of who would actually sign up for such a role. So in light of that, we might actually start to see professional personal representative companies emerge that will fill this role and that will have adequate insurance and indemnities in place to take on such liability, but time will tell. Another open issue is the availability and effect of GDPR compliance certifications. Companies would naturally like to be able to rely on a GDPR compliance certification mechanism in light of the onerous requirements and hefty penalties for non-compliance. And not only would such a mechanism alleviate concerns about a company's exposure to fines from supervisory authorities, but it would also foster a company's relationships with other businesses if they could show that they're certified as GDPR compliant. The GDPR itself doesn't provide for any such compliance certification mechanism, but it does, however, contemplate that the member state supervisory authorities and European Data Protection Board and European Commission will encourage the establishment of voluntary certification mechanisms and certification bodies. If and when certification mechanisms become available, however, the guidelines make it clear that any such certification would not prove compliance in and of itself, but could be used as an element in demonstrating compliance. speaking of compliance, companies that have taken steps to comply with the GDPR shouldn't take their feet off the gas pedal just yet, because there is new legislation pending in Europe known as the e-privacy regulation, or the EPR, that will replace the old European e-privacy directive. The EPR is intended to protect the confidentiality of electronic communications, specifically both the content and the metadata derived from such electronic communications, and it will continue the EU cookies policy under the old e-privacy directive, which requires websites to obtain consent from visitors to store or retrieve any information, such as through the use of cookie technology on a computer, a smartphone, or a tablet. It's expected to vastly limit unsolicited commercial electronic communications to individuals and the use of electronic communications data and metadata unless opt-in consent has been obtained. And it also requires companies to offer end users the same communication services whether or not such end users provide their consent to have their data collected. So what is the relationship of the EPR with the GDPR? Well, the EPR will be lex specialis to the GDPR, namely it will particularize and complement the GDPR with respect to electronic communications data that qualifies as personal data. All matters concerning the processing of personal data that are not specifically addressed by the e-privacy regulation will be covered by the GDPR. The current draft of the EPR provides for substantial penalties for noncompliance similar to the GDPR. Specifically, violations of the law may be subject to administrative fines of up to 20 million euro or 2 to 4% of the violator's total worldwide annual revenue, whichever is higher. So a draft of the law was approved by the European Parliament in the fall of 2017, and it's currently under review by the Council of the European Union. And for the law to be enacted, the Council must come to its own consensus on the draft and then negotiate the law's final language in a three-way discussion with the European Parliament and the European Commission. So it's expected to become effective in late 2018, early 2019. So that's an overview of what's pending in Europe, which will affect U.S. companies to varying degrees. But even if a company in the U.S. is not significantly impacted by the GDPR or the pending EPR, such companies should be aware of these laws and should stay tuned because the privacy regulatory landscape in the U.S. is evolving and has begun to follow Europe's lead. At the federal level, there are currently 2 privacy bills pending in Congress, the Consent Act and the Social Media Privacy Protection and Consumer Rights Act of 2018, both of which were introduced in April of this year. The current drafts of both of these pieces of legislation contain elements found in the GDPR and also the pending EPR, such as requiring opt-in consent to the use of sensitive information instead of allowing consumers to simply opt out, prohibiting companies from refusing to serve consumers who do not consent to the use and sharing of their information for commercial purposes, and requiring companies to provide users with a copy of the data that is being collected about them and information about who has access to their data. In addition to these 2 bills, the Federal Trade Commission and other federal agencies continue to be more and more aggressive in enforcement. And then at the state level, every state, as well as DC, Puerto Rico, Guam, and the Virgin Islands, have laws governing data breach notification processes. However, there are many variations from state to state, such as the actual content of the notifications and the timing and so forth. In addition, 13 states impose affirmative data security obligations on companies. These states require companies to implement reasonable administrative and technical protections. In New York, the SHIELD Act is currently pending, which would require companies to adopt reasonable safeguards to protect the security, confidentiality, and integrity of private information. The Act would also revise New York's current data breach notification law to provide for an alternative means for notifying people whose email account credentials have been compromised and to require certain specific information be included in breach notifications to consumers. In California, the California Online Privacy Protection Act requires operators of commercial websites that collect personally identifiable information from California residents to conspicuously post and comply with a privacy policy that meets specific requirements. One such requirement is that the privacy policy disclose how the operator responds to web browsers do not track signals. And also, California's Shine the Light law requires companies to disclose upon request of a California resident what personal information has been shared with third parties and the identity of the third parties with whom the information has been shared. In addition to these laws, about a month ago, California passed the California Consumer Privacy Act. This law was enacted on June 28th, and it will go into effect in January of 2020, and it builds upon the personal right to privacy embedded in the California Constitution. While the law is not as expansive as the GDPR, it's probably the most expansive data privacy legislation in the U.S., and there are a number of similarities to the GDPR and also to the pending EPR. For example, California residents can request disclosure and deletion by a business of specific non-public information collected by that business, which is similar to the right of access and the right to erasure contained in the GDPR. In addition, businesses cannot discriminate against consumers for exercising these rights, which is similar to the EPR requirement that companies provide users with the same communications services, regardless of whether such consumers consent to having their data collected. One difference, however, is that under the California law, companies can offer incentives to consumers for data collection if the collection practices are fully disclosed and the consumer opts in. Additionally, the law requires specific disclosures be contained in businesses' privacy policies or on their websites, and it mandates that businesses provide at least 2 methods for data requests, one of which must be a toll-free number. So that's an overview of the data privacy regulatory landscape in the U.S. And this chart here is intended to provide a visual summary of how the EU and U.S. privacy laws differ. And you can see from the chart that at the present time, the EU has much more stringent requirements than the U.S. In particular, the requirement that companies have a data protection officer and the enhanced rights of data subjects, such as the right of a copy to the data collected about them, the right to correct any inaccuracies in the data, and the right to have the data deleted. Additionally, in the EU, consumers have to opt in to marketing emails, whereas in the US, it is currently an opt-out model. And all of that being said, given the similarities between the recently enacted California privacy law and the GDPR and the pending EPR, the US may catch up to the EU over the next few years. And now I'm going to turn it back to Brett.
Thanks, Emily. That was a really terrific overview and connecting some dots, because the GDPR is a big, overarching 800-pound gorilla of a set of legal obligations that organizations on both sides of the pond, so to speak, need to deal with. But these additional U.S. obligations are ones that also form part of the context of what you're dealing with, and just complicate the compliance obligation and really make it almost a full-time undertaking for some part of certain kinds of organizations. So, the next step we want to talk about, so what do you do? And you may, particularly if you're feeling like this fellow here is just, very worn out by all of these requirements. So what should one practically do in light of this regulatory landscape that's much more complicated? So, the first thing we would suggest is you have to decide if your approach to the GDPR and your U.S. compliance obligations, assuming you have both of those to some extent, whether you're going to take a lowest common denominator approach or whether you're going to take more of a dual or a bifurcated approach and treat European data subjects one way, let's say, and non-European data subjects or individuals a different way. And I'd say, but for just observationally, having advised many companies around GDPR compliance and data privacy matters, and what we're seeing in the marketplace generally is that I think for the most part, unless you're a very sizable organization that's an internet company like Facebook, let's say, or a Google, you're probably taking the dual approach, at least for the time being, since the U.S. laws are much less rigorous, even if you take into account the pending California law, and treating European Union individuals and other people who might in some instances, including U.S. individuals who might be subject to the GDPR in a separate way. But anyway, that's one of those fundamental choices. And we do see some companies that say, hey, you know, we know that there are going to be additional obligations that one has to undertake for, let's say, U.S. Individuals who are not necessarily entitled to protections of the GDPR, but they just want to have a uniform, one-size-fits-all approach. And that's certainly fine, and they're just voluntarily assuming additional obligations. But I think the bifurcated dual approach is, at least for the time being, the more common approach. So, you know, for full GDPR compliance, what your organization needs to do is essentially work through and implement all of those applicable GDPR requirements that were highlighted in slides 3 through 10. And there's when you move down sort of the next layer down, there are lots of ticky requirements that that those slides just highlight. But essentially, you have to do all of that. And the new California law, you know, might also be something that you take into account as you're complying with the GDPR things, because some of the rights of access and the rights of disclosure are comparable, and 2020 will be here before we know it. But the overall direction that you want to take as an organization, in case there are later audits or reviews of your practices, is essentially seek to demonstrate that privacy is taken seriously, that you're not simply checking a box and not simply filling out a form and sort of thereafter forgetting about privacy. So some other things that ought to be done in this area, getting up to speed with GDPR and really data and cyber security obligations generally, is if you haven't already done so, you should audit and document your data handling processes and the safeguards for reasonableness and your ability to address data subject requests. Because those are all things, while they're good things to do, generally, those are specific things that you need to do to comply with GDPR, and you need to have processes in place to do that. You also should update your privacy and your data breach policies, and if you don't have a data breach policy. In our experience, many organizations have privacy policies because they've got a website that might be consumer-facing or customer-facing in some respect, or user-facing, but they don't necessarily have a policy for what you do in the case of a data breach. But you need that both for your internal and your external use. And as I said earlier, the documentation piece, to some extent, for GDPR compliance is the simpler part of it. All those getting your hands around the processes that you need to have in place to fulfill data subject request for access to information, disclosure of information, erasure of information, all of those sorts of things. Those are processes, and the more individuals whose data you have, the more complicated those processes can be. There's some neat products in the marketplace that make that simple, but even the simple products are difficult to use if your organization hasn't figured out some protocols and procedures for dealing with those processes. Also, you should consider, and in fact, under the GDPR, need to update your contracts to address vendor compliance issues and also customer and client concerns. So if you may not necessarily be feel that you've got a need to update your contracts for your own internal purposes, maybe you're good there, but you can certainly expect that your customers and clients, to the extent that you're handling any of their data for any particular reason, you're partnering with them, you're a provider to them, you're a contractor to them, you can expect that organizations are going to be asking you for these data protection addendums or data protection agreements, and you really need to focus on dotting your I's and crossing your T's. And as I said, it's a requirement of the GDPR that you actually have these things documented in a certain way. And in terms of another overall recommendation is take a look at insurance. The insurance marketplace has gotten very sophisticated around data privacy and cybersecurity insurance. I don't think it's quite caught up with GDPR specifically, But if you put GDPR aside, in general, the marketplace for cybersecurity products is much more sophisticated, and it probably will be catching up, and we'll be seeing some very GDPR-specific things. So the insurance marketplace might take a little bit of a breather in terms of if you wanted to go out and insure over your GDPR-related practices, but it will catch up. But insurance is something that is a big piece of risk management here. So those are some overall recommendations. Some more specific recommendations: contracting practices. We've seen these evolve significantly over the past several years as organizations have gotten much more smart and sophisticated about what they should ask for and what they should reasonably be required to provide to get rid of some of that contracting friction that we sometimes see where contracts get held up because there's lots of wrangling over certain kinds of issues, particularly indemnities and liability caps. So it's becoming fairly common, for instance, for data breach and data handling and confidentiality issues to be exceptions to liability caps, or exceptions where there are own sublimits of liability, perhaps up to insurance obligations, or insurance limits and the like. But so you have to get your contracting house in order. That's something that will keep you in very good stead with the GDPR. And to the extent that you're not maintaining, you may be maintaining cyber liability insurance, you might also consider requiring your vendors and contractors to provide that sort of insurance. So that's on the contracting side. Other things, so the GDPR requires certain administrative and technical safeguards. So on the administrative side, certainly training staff on cybersecurity awareness. So this is a good example of, we see a lot of organizations that want, let's say, a privacy policy, a GDPR compliance privacy policy prepared for compliance purposes, but aren't really paying attention to what's in that privacy policy. And one of the things that GDPR requires is that you not merely go through a documentation exercise, but that you really take this seriously. And in virtually every system where humans touch it, the humans are the weakest link. And so training is a big part of cybersecurity awareness. It will go a long way towards implementing these process requirements and insulating you for some of the bad things that could happen around data privacy mishaps and cybersecurity problems. So definitely train the staff around these processes that you'll be implementing. Consider the need for a chief privacy officer. If it's a GDPR issue, then it's a data protection officer, and that could very well be your chief privacy officer. But we're seeing organizations, as data becomes a much bigger part of what businesses of all types are dealing with, deciding to have a chief privacy officer or a chief compliance officer, or maybe it's your chief legal officer if you have one that deals with these issues, or a committee. But certainly to be thoughtful about having some individual or individuals in an organization being responsible for these things, these type of issues, cybersecurity and privacy. Limit access on a need-to-know basis. A lot of times we've seen data breaches where someone was given broader authority than they really needed to perform their job. And so really ask yourself, what data or what access do individuals need to perform their job functions? And if they don't need system-wide access, then curtail it. It'll go a long way toward helping you to, again, safeguard yourself against data breach problems and the cost of those. And it sort of goes hand in hand with that collect and retain data only for so long as you need it. And then when you don't need it, dispose of it properly. Shred it, destroy it, get rid of it in a permanent way. Certainly review and update your privacy policies, prepare a response plan, and to the extent you're subject to them or they're appropriate for your industry, follow best practices such as the PCI compliance guidelines. So technical safeguards, some technical safeguards that you might consider. Restrict data and password protected. I think this is almost goes without saying, but we're surprised when we see in the marketplace many organizations that don't password protect mobile devices, for instance. And it's fairly simple ounce of prevention that really makes up for pounds and pounds of cure later on. Use encryption. Encryption isn't quite a silver bullet, but it's a terrific safeguard, and it's becoming much more cost-effective and practical to do for data both at rest and in transit. Conduct periodic system security assessments, including those of your vendors. And it's not listed here, but one of the things that the GDPR allows you to do is you can certainly anonymize data, but more useful, you can pseudonymize data, so make it where it can't be readily read, but it has to be deciphered essentially. So some final thoughts and takeaways before we go into the Q&A. As both Emily and I have said, cybersecurity and data privacy compliance is definitely here to stay, and it's a much bigger part of even the most unexpected types of businesses and organizations, nonprofits, pretty much any organization dealing with data, and it's a much more serious compliance obligation. It requires more attention and resources. As we said earlier, it's not too late. If you haven't fully complied with GDPR and you think that you have those obligations, you're in good company. And because, as Emily was noting, the regulators in Europe really are catching their own breath and getting up to speed, and they're not fully staffed. There's really this window of opportunity to get into compliance before the regulatory environment gets much stricter, and at some point it will. And the initial poster children for bad practices may be egregious bad practices, but some of those practices that will be highlighted undoubtedly will be ones that might be relatively innocuous. But now there's still time to get into compliance. And so it's very much a process, and in the words of Winston Churchill, which I won't read here, but I think sort of summarizes this idea of a journey, and it's not a check-the-box exercise. So with that, I think we have a handful of questions that were noted, and maybe Emily, you want to take this?
Sure.
Take this first one.
Sure. So the first question we've received is, are corporate entities considered natural persons under the GDPR? And the answer is that no, corporate entities are not considered natural persons under the GDPR, and that the GDPR is intended to protect individual natural persons as opposed to legal entities. But my understanding actually is that the EPR is different in this regard, and that the pending e-privacy regulation, which is will specifically protect the confidentiality of electronic communications, that regulation will apply to legal entities as well as individual natural persons.
Yeah, that's a good observation. And one thing incidental to that, because it's a gray area, is this question about whether corporate entities are natural persons. Corporate entities employ individuals who have lots of business data that can be used to identify natural persons, such as a business email address. And it's a serious question, not very clear, because it's business data. A business email, for instance, or other information that you might have in a CRM database about a customer, is that protected under the GDPR? Well, the GDPR is intended to protect personal information of individuals from which they can be identified. So literally, a business email address would be protected under the GDPR, even though it's not typically the kind of information that one would think about as being personal data or things that are very confidential. But yet, it's out there, and so just thought I'd mention that. There's another question. Wonder if you want to address this, Emily, too, if you can read that. It's about a question about, what if I only do business with the EU person only in the U.S.? So we're only dealing with the
and the entity that's doing business is located outside the EU.
Right, outside the EU. It's a U.S. company.
Right. It's honestly a little bit unclear, given that you're doing business with an EU citizen, but that's one of those gray areas. But from the text of the GDPR, it seems like it's more territorial based. So if everything is being done outside of the EU and the EU citizen is not actually located in the EU, then likely the GDPR would not apply. I don't know, Brett, you want to elaborate on that?
Yeah, I think that's generally right. But you could change those situations. So if you're doing business with the EU person, and I think under the question that's being posed is the EU citizen is also in the US for whatever reason. But if the EU person is coming to the US, let's say to take advantage of a service offering, and that's the reason you're doing business with them, that's been targeted to them when they were in Europe, then they would be subject to the GDPR. But you know, there's this hypersensitivity around EU people with the GDPR that all of a sudden they're almost like they're radioactive, and we've got to be super careful about touching residents or citizens of Europe. And the idea there is as we noted earlier, it's not specifically, the GDPR is not specifically protective only of European individuals, although certainly it's protective of them in the appropriate context, but potentially it's even protective of US individuals whose data is being processed over in Europe or by an entity over in Europe, that cloud service example. But I think if you're just dealing with an EU person, not as part of any sort of service offering or goods offering, you haven't enticed them to come into the marketplace by some offering that's targeted in Europe, then just because they're a European citizen, and your activities are solely in the borders of the US, GDPR ought not to apply in that situation. I think the better reading of it isn't, but it's confusing, and I think it's those kinds of situations that are causing some confusion by businesses in the US when they're encountering a European person, and you really have to look at the specifics, the context. You know, why are you dealing with them? What's going on in your dealings? What kind of information is involved, and so on. So I don't know that we have any other questions at the moment. Scrolling through the screen, those are both really good questions and highlight some interesting considerations. Emily, do you have any other comments?
I think we've covered most everything.
Well, thank you so much for your time and attention today. I believe we'll be pushing out and emailing attendees the slides that we went through today. And if you have further questions, we would be delighted to address them. And just feel free to contact us by email, phone, or otherwise. And thank you so much.
Thank you.
Thank you for joining us today. Please be sure you provided your email address during the registration process, as we will be sending a PDF copy of this presentation, as well as the link to the recorded webinar. And for more information on upcoming webinars or events, please contact us at sgrcommunications@sgrlaw.com or visit our website for more information at sgrlaw.com. Thank you and have a great day.